Hello everyone and welcome to StudyIQ English. I am Joycey Joy and in this video we are going to discuss about financial emergency. We know that there are three types of emergencies: national emergency, state emergency or the president's rule, and then the financial emergency. Financial emergency is concerned with the economy of the country. So we will be discussing about financial emergency in this video. Let's get started. First, let us understand what is a ground of declaration of a financial emergency. From the term itself, it is clear that there is an emergency situation with regard to the financial resources of the country. That is, the financial resources of the country is undergoing a crisis, or the government doesn't have enough financial resources, or a situation has arisen such that the government is not able to use its financial resources judiciously, or there is a lack of financial resources to maintain the needs of the economy. So let's see what is the background or what's the ground of declaration of a financial emergency. According to Article 360, so financial emergency is mentioned in the Constitution under Article 360, which means that financial emergency is a constitutional provision. The other two emergencies as well as are constitutional provisions, that is Article 352 and Article 356 of the Constitution respectively talks about national emergency as well as the President's rule. Whereas financial emergency is mentioned in Article 360, which means it's a constitutional provision. Article 360 of the Constitution says that if the President of the country, President is the nominal executive of the country, nominal head of the country, of the state. So, if the President is satisfied that a situation has arisen due to which the financial stability or credit of India or any part of its territory is threatened. So, this is the situation. Now see, here you will understand that the Constitution has not given any specific situation, for example, a war or any kind of pandemic. No such specific incidents or no such specific situations are mentioned in the Constitution. Constitution has given the authority to the President to define such a situation which leads to a financial emergency. So according to the Constitution, if the President of the country is satisfied that such a situation has arisen in the country which has led to a financial instability in the economy or a situation which affects the credit of the country as a whole or any part, any territory of the country. So this is the will of the President, or we can say this is a discretion of the President. Now we also know that the President has to act with respect to the aid and advice of the Council of Ministers, which is headed by the Prime Minister. So can we really say that it is the discretion of the President to decide a financial emergency in the country? No. Why? Because the same Constitution has also said that the President has to act in the aid and advice of the Council of Ministers, that is the real executive, which is headed by the Prime Minister. So we can say that according to Constitution, it is the President who declares the financial emergency, but according to the aid and advice of the ministers, that is the Council of Ministers headed by the Prime Minister. Next, we are coming to a few amendments with regard to financial emergency. The first one is 38th Constitutional Amendment Act and next is the 44th Constitutional Amendment Act. Coming to 38th Amendment Act, which was in the year 1975. Now, the satisfaction of the President in declaring a financial emergency is final and conclusive and not questionable in any court on any ground. This was the amendment made in 1975. Which was the 38th Constitutional Amendment Act. See, in the 38th Constitutional Amendment Act, it was made a provision that the financial emergency declared by the President is final, which cannot be questioned by any court. That means there is no scope for judicial review. What is meant by a judicial review? A judicial review means that any law passed by the Parliament or any executive action taken in the name of the President of the country can be questioned in a court of law, or the judiciary has the authority to overlook into it, to look into whether the provisions made in the law or in the executive order is in compliance with the constitution or not, because Supreme Court is the guardian of the constitution, also the custodian of the constitution. So in that respect, Supreme Court as the guardian, as the protector of constitution, and in specific the fundamental rights, has all the authority to see whether a law made in the country or whether any executive action taken in the country is compliable or whether it is in compliance with the provisions of the constitution. That is what we call as a judicial review, the authority of the court to look into the provisions of various laws made in the country. Now, the 38th Constitutional Amendment Act of 1975 made it that the financial emergency declared by the President on any ground according to the discretion of the President cannot be questioned in any court of law, which means there is no judicial review or scope of judicial review for financial emergency. Now coming to 44th Amendment Act of 1978. In the 44th Amendment Act of 1978, this provision was deleted. That is the provision which was added by the 38th Amendment Act. What was 38th Amendment Act? It was that there is no scope for judicial review. That provision was removed or deleted, which implies that the satisfaction of the President is not beyond judicial review. This is very important. So 44th Amendment Act made it clear that the financial emergency declared by the President can undergo judicial review, or it's not outside the purview of the or outside the scope of the judicial review. Judicial review can be applied to or applicable to the financial emergency declared by the President. That was the 44th Amendment Act of 1978. Next is the Parliament approval for financial emergency and the duration of financial emergency. The Parliament, which means both the houses of Parliament, Lok Sabha, which is the lower house, and Rajya Sabha, which is the upper house of the Parliament. So, Lok Sabha and Rajya Sabha, both the houses must approve the financial emergency within 2 months from the date of its issue. That is, within 2 months of issuing financial emergency, both the houses of the Parliament should approve it, and it is passed by a simple majority. Simple majority is majority of the members present and voting. Financial emergency continues indefinitely till it is revoked, which means that there is no particular period for financial emergency. It continues until it is revoked, and it may be revoked by the President at any point of time. President declares the financial emergency, also the President can revoke it at any point of time. So there is no particular duration for a financial emergency. Now, the notable fact here is that no financial emergency has been declared in India. So no such emergency has been declared in India. Even though we had many cases of state emergency and President's rule and also national emergency, no financial emergency was declared in India. It's an important fact. Now let's come to the effects of financial emergency. The extension of executive authority of the center over the financial matters of the states. Now you have to listen or you have to see carefully what are the effects of financial emergency, and in particular you have to note how does it affect the center-state relationship, how does it affect the federal structure of the country. We'll come to the discussion over it later, but first try to understand the effects of financial emergency. First is that the executive authority of the center will be extended over the financial matters of the states, which means the central government becomes empowered to take financial decisions respective to states, in respect to the states. So that is the first effect or the impact. Second one is reduction of salaries and allowances of any class of persons serving the states or the union, and including the judges of the Supreme Court and the High Courts. So this is again very important, that during a financial emergency, any person working under the state government or under the central government, under any class, A, B or C, any class of employees working under the government, either the state or the central government, may undergo a reduction in salary. This is applicable or extendable even to the salaries of Supreme Court as well as High Court judges. So their salaries also may get affected during the financial emergency. Here what is to be noted is that it is not a compulsory provision, it can be an impact of the financial emergency. And there would be reservation of all money bills for the consideration of the President. All the money bills will be reserved for the consideration of the President. Now, let's come to the criticism of financial emergency. We have already seen that during a financial emergency, the executive authority of the central government falls even on the state government to take various financial decisions. This definitely affects the federal structure of the country. How? India is a federal country with central government and then the state governments also. And state governments are given their own independence in their own respective areas, and central government their own freedom and their own right to take decisions on their respective areas. Constitution has clearly defined three lists: the union list, the state list and the concurrent list. For the union list, all the subjects falling under it falls within the jurisdiction of the central government, and for the state list, all the subjects falling within the state list comes under the state government, and for the concurrent list, both the center and the states can make laws. But in case if the state and the central government makes law on a particular subject, the central law remains to prevail over it. And there is also a residuary list for which the central government is empowered to make laws for it. So we have a clear-cut distinction of powers between the center and the states, not just in financial matters but also in all arenas. So the criticism, one of the major criticism of financial emergency is that the federal character of the constitution will be destroyed. How? The central government gets empowered to make financial decisions on the state subjects as well, or over those subjects for which the state has authority. The power of state in the hands of central government or the union executive. The financial powers get transferred to the union government. The president will become a dictator. Even though this is not right in its real sense, we can still say that. Why? Because the president is not the dictator. President has to act on the aid and advice of the council of ministers, which is the central executive. So president becomes a dictator, but according to the will or the aid and advice of the council of ministers. The financial autonomy of the state will be nullified because the states no longer will enjoy its freedom and authority to make financial decisions, rather it will be transferred to the central government. The fundamental rights would become meaningless. These are some of the criticisms that the financial emergency faces in the country. So this is about financial emergency in brief. I hope this was a useful one for you. Thank you so much for watching. I wish you all the very best.